Hello everyone, and welcome to International Business Law. I will be your instructor, Torres-Spelliscy. This week is about introductions, both of ourselves as well as introducing some fundamental principles of international law. It truly is a fascinating time in the international business world. With advents in technology, communications, and transportation, never before have businesses, particularly small businesses, been so primed to trade with global partners. Indeed, it used to be that a global trading firm required a substantial market presence, vast resources, and government connections before international trade became profitable. That's simply not true anymore. With a simple click, the smallest of businesses can contract to do business with buyers and sellers in a global marketplace. Indeed, as U.S. President Barack Obama remarked in his 2014 State of the Union speech, 98% of exporters are small business.
Let's do more to help the entrepreneurs and small business owners who create most new jobs in America. Over the past 5 years, my administration has made more loans to small business owners than any other. And when 98% of our exporters are small businesses, new trade partnerships with Europe and the Asia Pacific will help them create even more jobs. We need to work together on tools like bipartisan trade promotion authority to protect our workers, protect our environment, and open new markets to new goods stamped made in the USA. Listen, China and Europe aren't standing on the sidelines, and neither should we.
Now that's from a volume number. Most of the trading is obviously done by large firms. But from a volume number, sheer number of participants, 98% of U.S. exporters are small businesses. So as a potential business owner, the opportunities associated with participation in the global marketplace are vast. Companies can engage in direct import and exports of goods, widening their pool of suppliers, customers, materials, and knowledge that are available to help the brand grow. Or a business person could engage with an international trading company or a representative to export goods on its behalf. There are also ways to establish your brand in foreign jurisdictions, whether by licensing your intellectual property rights or by opening a subsidiary or joint venture. But the road is also marked by perils. In order to be effective in international business, and this is true in all businesses, but particular international businesses, the business person needs to understand the rules and regulations governing international transactions. To develop these understandings and put you on the path to success will be one of the main purposes of our course this semester. So let me begin by introducing myself. I'm a lawyer by trade. I've been teaching law and business courses since 2008. Before starting to teach full-time, I practiced law in New York City for a decade, working at one of the largest and most respected firms in the country, Arnold & Porter, LLP. Part of what I try to do in my classes is to draw on those real-world experiences to impart to you the relevancy of international legal issues to your everyday life as a business person. You see, in practice, one of the first things I always had to do with a new client was to sit down and to educate them about the risks and opportunities associated with international business. The rules they had to be aware of, what they could use to their benefit, how best to protect themselves as they entered the international marketplace. And you'll hear me talk a lot about these experiences throughout the course. And indeed, I want to think of this class, I want us to take a business perspective in the class. See, every business decision a person makes has legal implications. In my practice, I spend a lot of time in front of various boards of directors talking about the legal risks associated with certain business decisions. So that's the approach I want us to take here. Let's imagine that we're weighing business decisions and trying to decide an appropriate strategy given the legal ramifications of our various options. Now, throughout the course, you'll also hear me say that understanding the laws which control and regulate your organization's behavior is a critical component of your organization's financial success and longevity. Why? Well, in short, the law's primary purpose is to establish rules needed for societies to live and work together. Whether its goal is to protect you from harm, to punish wrongdoers, or to maintain social order, the law seeks to enforce the accepted rules of the game. It does this through a construction of common understandings, agreements, written or otherwise, about what certain words mean, what actions mean, and the consequences that might result. So this is critical for business. By creating predictable patterns of behavior, the law facilitates orderly business transactions. Now, as I suggested above, with the growing number of companies engaging in trade law and understanding trade law is becoming an increasingly important skill for the modern business person. Over the last 50 years, the value of trade to the world economy has increased by approximately 250%. That's a dramatic increase by any measurement. As a result, in order to understand the potential of modern business, the business person must now also understand the potential of international business. So our course begins there, with a discussion of certain fundamental principles of international law, like where it comes from, who it applies to, and how it seeks to resolve disputes. In addressing the question of where it comes from, we'll study topics like treaties and something known as customary law, which is where in the absence of a written law, certain long-standing practices may acquire a legal status, provided conditions are met. In discussing who it applies to, we'll discuss the concept of states and responsibility, as well as international organizations like the EU, NAFTA, the WTO. Finally, we will discuss the various ways that parties can seek to have their disputes resolved. You see, business disputes are an unfortunate reality of practice. I can guarantee you that as a business person, you're going to be involved in multiple business disputes. The settlement of such disputes on an international level can occur through a myriad of mechanisms, only one of which is litigation. And indeed, litigation may not always be the most efficient way to settle a dispute from the business perspective. Why? Well, first, litigation is public and noisy. There are ways to minimize how much information can leak from a litigation, but litigations are public records, and so are the proceedings associated with them. That might not be a good thing from your perspective as a business, and indeed, in your opinion, confidentiality might be key. Now, the second reason litigation may not be ideal is that it is expensive. Part of the reason it is so expensive is also the third reason why it might not be desirable, and that's because litigation takes time. There are procedures that must be followed to ensure fairness, and those procedures are intricate and build in time to allow parties to craft the best arguments they can in favor of their respective positions. So as a result, a business must be aware of alternative dispute resolution methods such as arbitration, mediation, and negotiation. In fact, dispute resolution in business really is about the generalized art of negotiation, about resolving disputes, either through third parties, like arbitrators and mediators, through direct negotiations, or potentially through litigation. With respect to litigation, we'll talk about various forums that might be available to states, like the International Court of Justice. We'll also talk about the International Center for the Settlement of Investment Disputes, which is open to investors, foreign investors who think they've been wronged. And we'll talk about various dispute resolution bodies at the WTO. And indeed, from a trade perspective, the dispute settlement body at the WTO may be one of the most important avenues that states have to resolve international economic disputes. Now, we have to remember that the reality is most business disputes, including international ones, are handled in domestic courts. So we will conclude our discussion of the topic with questions relating to the idea of jurisdiction. That means, when does a court have the authority to make a binding decision? And authority is broken down into two legal concepts. The court needs both the authority over the person, known as personal jurisdiction. That's the right to call somebody into the courtroom and to impose a binding decision on them, personal jurisdiction. And the court also needs what's called subject matter jurisdiction. That means the right to decide about a particular topic. And courts sometimes have limited jurisdiction and only have the rights to decide about a limited number of areas. So we talk about questions of jurisdiction, and we'll also talk about potential limitations if you're trying to bring a suit against a foreign government in a domestic court, what kind of hurdles you may have to clear. So let me offer a few just kind of concluding thoughts. This is probably an area of law that you have not given a lot of thought to. We have a lot of work ahead of us. There's a lot of ground to cover and not very much time to do so. Now, the study of international law can be tricky. It's not necessarily intuitive from what we experience in our daily lives. I think we all interact with domestic laws on a regular basis, and it's usually quite obvious, whether you're making a purchase, engaging in contract law, or interacting with people, which engages aspects of tort law. We see domestic law operating on a daily basis. But the same isn't true about international law, and that's because the interactions with international law occur at a deeper level. Make no mistake, the goods that are available to you, the cost of those goods, where they're coming from, your jobs, all those things are affected by international law. Now, as we study this body of law, we do have to remember that it's still relatively young. So there are areas that are either not developed at all or are poorly developed. You see, we have to remember that most of the modern trade regime was constructed within the last 75 years in the aftermath of World War II. So there are going to be areas where the answer to a particular question seems unsatisfying. Well, while that may be frustrating at points, it also provides us with an opportunity. We are one of the first couple generations to be able to shape what the law will say about various important economic issues. That's a tremendous responsibility, but it is also a tremendous opportunity. So I hope you enjoy the course. I always like teaching this one. Don't hesitate to contact me if you have any questions, and I will see you on the discussion boards.